Good morning, and thank you very much for joining us. I am Iyori Folani. Okay, let's look at the latest, I think, election petition tribunal. That's of the governorship in Nasarawa State, where the tribunal has actually sacked the Nasarawa State governor, APC's Abdullahi Sule, by a 2-to-1 majority decision. The tribunal, faulted the declaration by INEC of the declaration of the sitting governor, and had said that INEC should withdraw its certificate of return and issue same to PDP's David Ombugadu. Well, let's look at that. Of course, APC has been APC in Nasarawa State has been quick to say that it'll appeal, and indeed, I think has given such notice, and that it stands by its governor. The governor, for his part, has also said that everybody should be calm. Let's just pursue this to a logical conclusion. Of course, APC and the governor going with the minority decision, which was delivered by Justice Ibrahim Mashi, saying that PDP's case lacked merit and failed to prove the case of the PDP. Okay, to help us look at it, in studio, we have Dr. Mubarak Adekilekun. He's a legal practitioner. A fine morning to you. Thank you very much for coming on our program.
Good morning to you, and thanks for having me here.
Indeed. Okay, so help us understand, especially against the backdrop of this was not a unanimous decision. It wasn't an unanimous decision in that there were three justices. Two said the petitioner had won, and one delivered a minority decision. So it was dissenting in the sense that it said that the PDP's case lacked merit. Help us understand what the issues were that was considered by the lordships.
Thank you very much. The petitioners, in their petition, claimed a part of their prayers was that the PDP candidate, David Ombugadu, led with 4,130 votes. Especially, their claims were that some votes were not properly collated at the ward levels, while in some areas they alleged overvotings. Now, in the prayer, like I told you, they wanted the tribunal to declare them with 4,130 votes, whereas in their final written address, they came to the conclusion that the margin actually was 841 votes. So they abandoned their claims as one of the reliefs in the main petition, where they initially said they won with 4,130. At the end of the arguments and the filing of the written addresses, they included it that they were wrong. That's the implication. That now it is just for 8,841 votes. The tribunal extensively, like you said, it was a split decision. Two of their lordships say David Ombugadu won the election with 841 votes. Then the dissenting judgment of Honorable Justice Mashi stated that Governor Abdullahi Sule won with a margin of almost 3,700 something votes. So that is the decision between the two. Two of them examined the claims of both the petitioners and the respondents and came to the conclusion, the majority says, it is Ombugadu that ought to be declared as the winner, and therefore it was declared. That the election conducted in Nasarawa State was not conducted in substantial compliance with the provisions of the Electoral Acts, whereas the dissenting judgments claimed otherwise, that the governor was properly elected and should remain the governor of Nasarawa State, and that the election was conducted in substantial compliance with the provisions. So the dissenting judgment dismissed the petition of the petitioners.
Mm-hmm. Now, thank you very much. Now, the lordships were actually, they necessarily had to deal with the same evidence before the court, before the tribunal. And I suppose this is why, tribunals are peopled by, an odd number of judges so that you can see it. If it's 5, then it's not possible to have an equal deuce kind of a situation. The governor and APC in Nasarawa State has said immediately that it's going to be appealing. From your point of view as a lawyer yourself, how come, well, it's not so much how come, what do you think was the reasoning? Because that Justice Ibrahim Mashi, had said that his learned colleagues, that was their opinion, and so we had that split decision. But he needed to put it on record that, as far as he was concerned, the case lacked merit. And that was, I thought that was particularly strong language. It lacked merit and failed to prove the case of the PDP. So, as I said, same evidence before the lordships, one seeing it so differently. What, if you were to hazard a guess, what do you think it was that they shall now be taking to appeal? Because they have signified that they will be appealing.
Thank you very much. After the respondents were served with the copies of the petition, naturally, in an election petition, because we see election petition is sui generis, meaning that it is a class on its own. We represented the governor, the second respondent, and we filed series of preliminary objections to the competence of the petition, and also answered the petitioners in respect of all their allegations. Thirdly, the second respondent also came out and said, since the petitioner were challenging that some of the votes were excluded, that the vote of the second and third respondent, that is the governor himself and the APC, were also excluded. Additionally, in compliance with paragraph 18 of the Electoral Act, which says that a respondent can also object to the vote of the petitioners, we also objected to the votes of the petitioners, especially, naturally, in the areas where they are on diverse grounds, including overvoting, non-accreditation, etc. Now, like you said, one of the reasons why we consider it very strong to go on appeal, let me take it from the preliminary objection that the second respondent, I'm speaking for the second respondent now, filed, okay, or the counsel on behalf of the governor filed. Like I said, the election petition is sui generis. We have said that the prayers in their petitions were ungrantable. I won't talk like a lawyer now. Let me come down to the level of a layman.
Oh, okay.
Sorry,
so that's not necessarily a legal term. That's not necessarily a legal term, ungrantable. You say you're not speaking as a lawyer and using that word.
No, I want to just make some kind of analysis. In an election petition, if you are challenging that the election conducted in Nasarawa State on the 18th of March 2023 was not in compliance with the provisions of the Electoral Act, naturally, you need to seek that election which you claim was not in compliance must be nullified. The petitioners never asked the tribunal. There was no prayer as to the nullification of the election, because you have alleged that that election was not in compliance. And that was the decision of the tribunal. The majority decision was also that election was not in compliance with the provisions of the Electoral Act, the manual, and the guidelines. Now, if that is the case, should the petitioners not have asked for a prayer to nullify the election conducted on the 18th day of March? This is very fundamental. The part of the reliefs they brought was, withdraw the certificate of return of Governor Sule and then declare Obodu, and he should be sworn in forthwith, which the tribunal granted. But because the election petition is sui generis, having not asked for that prayers, and we say the courts and tribunals are not Father Christmas, we have stated that this is very, very cardinal. How can you issue a certificate of return to somebody and you never sought for the nullification of the election of the sitting governor? It will create chaos. We have brought all these arguments. They were argued. Another point, which is also very important here, is an election petition. We have what we call grounds of the election. They are just like foundation. And the fact that you build on those grounds must not be incongruous with the grounds that you have. For example, the petitioner's only ground, the sole ground of the petitioners, was that Governor Sule did not win by majority of lawful votes cast at the election. This presupposes that any facts relating to non-compliance, relating to non-qualification, or relating to malpractices or corrupt practices should not be built on that sole ground of not winning by a majority of lawful votes cast at the election. We have also objected to this, that this is not possible. Since you came with just only one ground, all the facts must be built and must not be incongruous with the ground of the petition. The tribunal, in its wisdom, glossed over. We have very potent preliminary objections. Part of what the tribunal said, why they glossed over it, was that our objection was just too technical. And technicality is part of the law. Why are we lawyers? Also in an election petition, which we say it is a class of its own. If your facts that you have led, evidence you have led, were in support of the ground of non-compliance with the provision of the Electoral Act, naturally, all those evidence should be demolished. The petitioners allege in several polling units that the election was not conducted, because if you say there was overvoting, you are trying to say that the total number of votes cast exceeded the total number of accredited voters in that polling unit. And that means that you are alleging that, yes, there was non-compliance with the provisions of the Electoral Act. But as I'm saying, the only ground of that petition was just on the fact that Governor Sule did not win by a majority of lawful votes cast at that election. So we have brought series of objections that naturally or ordinarily should even demolish, or there are jurisdictional issues that we believe that, having reviewed, examined all these objections, the tribunal should have come to a conclusion that these objections are put and the petition hereby dismissed. The only thing the tribunal said in just 2 paragraphs was that this election petition they agreed that it's sui generis, but however, that going to determine that preliminary objection will be like emphasizing on technicalities, which will not be in the interest of substantial justice. That was all. Now, another thing that I told you, that the petition, the respondent also claimed that some of our votes in certain units and wards were reduced. We brought in witnesses. In the third allegation, that we also objected to the vote of the petitioners. We brought in witnesses with tender document to show that there were certain areas where there were overvoting. And these were areas where the petitioners won overwhelmingly. In those areas, the tribunal just disagreed with us and entered judgment in favor of the petitioners. So I believe that these are some of the major grounds that we are going to test at the Court of Appeal. Another very important one, before I go, is that we said, man said in Chiroma ward, in Gayam ward, Chiroma has 102 or 103 polling units. Gayam ward in Lafia has 58 polling units. In Chiroma, the petitioner has called only just one witness, who was the ward coalition agent of the party. He came, he testified. At the end of the day, in his depositions, the evidence he gave in court was that all the things that transpired at the various polling units were narrated to him by the polling units who were never called. No single polling unit was called in the whole of Gayam ward. No single that has one polling unit. They called only just one single witness. No single polling agent was called in the whole of Gayam ward. None was called in Chiroma ward, like I said. We said, come, this is not possible. The evidence will be tantamount to hearsay. But the tribunal said no, surprisingly, that the evidence of the petitioners were purely documentary. They relied on the provision of Section 137 of the Electoral Act, which the Supreme Court has even whittled down in case of Oyetola and INEC. That the case of the petitioners was just documentary, that even if they called just one single witness for the whole case, that would be enough for them. Say, come, that Section 137 of the Electoral Act being referred to, talk about non-compliance. That provision says that where you are alleging non-compliance and you have brought originals or certified true copies of documents, it shall not be necessary for you to call more than maybe one witness. Like I said, the petitioners include a ground of non-compliance? Because that provision is, 137 is talking about non-compliance with the provision of the Electoral Act. It therefore presupposes that even if you want to invoke that provision of Section 137, the petitioners ought to have come under the ground of non-compliance, added to the only ground that they brought. All these things were argued.
Thank you very much.
The wisdom of the tribunal.
For interrupting you. Thank you very much. Thank you. And also for simplifying it so that ordinary people can understand it. But let me bring on Mr. Mahmoud, who has called in from Lagos. Thank you for holding on, Mahmoud. Go ahead, please.
Yeah, good morning.
Good morning.
Yeah, I'm not a lawyer, but as somebody who is educated, from what Dr. Mubarak is saying, there is no way. There are three judges, and then two was for Ombugadu, in favor of the rule in favor of Ombugadu. And then the other, the third one, one Judge Mashi, ruled in favor of APC. From the evidence before them, I don't think they erred in law. They gave to the person who won the majority votes, as far as we are concerned. Because what I've been having in Nasarawa State is a one-man show. I just want to digress to what happened during the National Assembly election. Two factions, somebody had election in one area, another faction had another area, and the governor was saying that he cannot work with somebody. What the governor came to say, sorry to take you back. Governor was saying that he cannot work with the person. He can only work with Balarabe. What sort of democracy is that? Look, these are our leaders. They will set this country on fire one day. I wish him good luck, and I wish Dr. Mubarak good luck. You can go to appeal, you can even go to a Supreme Court. God will bring the actual winner of the election. Thank you very much.
Indeed. Thank you very much. So as I was saying, Dr. Adekileku, well, the part that most people will be able to grab hold of was the point you made about the petitioners alleging that the conduct of the election and the victory of the governor was not in substantial compliance with the Electoral Act. But you did point out something that we've heard lawyers say over and over and over on our programs, that the courts are no Father Christmas. And that if you haven't asked for a thing, it is not their business to be going shopping and saying, how about this? Don't you think this is also useful? Don't you think this is... They say that's not what the courts do. They limit themselves to what is before them. And so I suppose many people will be able to relate to that in a non-technical sort of way, waiting, of course, for the appeal court to pronounce on it. But they'll be able to relate to that, I was imagining. The point you made that they were, that very, as you explained it, that some substantial non-compliance would appear to now be good in as long as you strip one of the office, of the spoils of that victory, and then hand it to another. Isn't that still under what has been alleged to be a substantially non-compliant election with the Electoral Act? I guess if you didn't know anything about it, just going by what you have explained to us, that would be something that their lordships will have to also determine whether it is possible for the non-compliance to fault one man but benefit another.
Thank you very much. That's one of the major areas where we are faulting. Of course, like I always say, Tribunal, a majority decision says Mbugadu is the winner until it is set aside. That is the law.
Yes.
The dissenting judgment, even though it says Governor Sule is the winner, it is a minority judgment. That is not the majority. But Electoral Act gives any respondent whose election has been annulled 21 days within which to appeal. So, as I was saying, one of the most important things in this is, you have said the election did not comply with the provisions of the Electoral Act. There was no ground for non-compliance. The ground, like I said, they are the foundation. If the foundation is not properly erected, there is nothing you can build on it. Aha. You cannot build something on nothing and expect it to stand. And well, that's why lawyers always, people always look at lawyers and say, maybe lawyers, they are not. These are law.
Okay.
And we
sorry to interrupt you again. Let me bring in Mr. Mohammed, who is calling from Abuja. Good morning to you, Mohammed.
Good morning, Uncle Yori. Good morning to your guests.
Yes, thank you. Good morning.
Yeah, thank you. My only question, did the petitioners been able to bring evidence in court? Have they been able to bring the evidence in court? Because some of the information we had is like they just rely on IREF, the way Osun State Tribunal rely on, and then gave judgment to the petitioners. Later on, the judgment was cancelled. The victory was cancelled in Court of Appeal. Did the petitioners be able to bring evidence the way APC brought evidence in Kano in court? That's what I want to find out. Because they cannot rely on IREP, because the presidential election too, they say they cannot rely on IREP results to declare somebody as a winner. So how can Nasarawa case be different with other cases, other states? So that's my question. Thank you.
Thank you very much, Mr. Mohammed, for bringing it. Okay.
In law, there is what we call ser decisis, or we call it the rule of judicial discipline, that the judges are also bound by the decisions of the appellate courts in whatever other decisions they want to take. The petitioner subpoenaed some witnesses. At least most of you in recent, was it 6th of September this year, that the Court of Appeal decided the cases of Atiku Abubakar against Bola Tinubu and INEC and others, and also Peter Obi. One of the major decisions of the Court of Appeal was that subpoenaed witnesses ought to have filed their written statement on oath, and that their names must have been listed with the petition within 21 days of presentation of the petition. Same thing happened in Nasarawa. All the people that brought that IRF that he was referring to, they were subpoenaed by the petitioners. We cited the case of Obi, Peter Gregory Obi, against INEC to the tribunal. Surprisingly, the tribunal just didn't even refer to it. The tribunal started citing the cases of Olubumiete, the cases that were decided early in 1990 or 2000 or something, with the recent decisions of full court of the Court of Appeal, that would have been a nice cleaning exercise. All the evidence given by the subpoena witnesses, either from INEC, and let me tell you, the petitioner subpoenaed witnesses from PRP, People's Redemption Party, and another one. They were subpoena witnesses. They also subpoenaed witnesses from INEC who brought in IREV copies. Almost all the IREV copies were brought in by subpoena witnesses. We cited the case of Peter Obi and Atiku, that all their evidence and the documents brought in by them, because if the court says, come, you are not entitled to testify, then all the documents brought by you should also go. We cited all these ones. The tribunal didn't even refer to it. And that's why I say there is what we call the doctrine of stare decisis, that the binding force of precedent. Once you have a precedent by an appellate or higher court, you are bound to follow it. And that is where the issue of judicial discipline comes in. That is, those are part of the grounds. Now, the petitioners brought in an attempt to prove.
Can you hold on, please, while I bring on another caller who wants to contribute to the program? Sorry for that. Good morning, Mr. George.
Good morning, Uncle Yari.
Yeah.
Good morning to your guest, too.
Yes, Dr. Mubarak.
Uncle Yari, I think the National Assembly needs to tinker with the Electoral Act, because the elections are beginning to take a new dimension in Nigeria. It's like the judiciary is about to replace INEC. We shouldn't allow this trend to continue. How do you start talking about overvoting in an election where BVAS machines were used? You remember that was the same thing, the same allegations that were made in Osun. INEC insisted that there was no overvoting, but the tribunal, said there was overvoting, only for them to get to the higher court, and the higher court said there was no overvoting. I think the credibility of INEC should be improved, or we should rely on what INEC is saying, except that there are strong evidence to show that what INEC is saying is not the correct thing. But for the judiciary to be using technicalities to determine the fate of a governorship election is risky. So there is a need for the National Assembly to take a second look at the Electoral Act, so that it doesn't, when people lose elections or win elections, they should learn how to accept the result of elections. If I were the National Assembly, I would put a clause in the Electoral Act that if you are protesting that you are the one that won, and you get to the court and you lose, you pay a fine of not less than R1 billion. So it is only those who really have a case that will want to pursue the case in court. The way the things are going now, we are looking like a country where there is no trust in our electoral system, there is no even trust in our judicial system, as if this is just anybody's game. It's not a good trend.
Okay.
That's my view.
Thank you very much for calling in, Mr. George.